Live from Washington, D.C., Sekulow Live. Phone lines are open for your questions right now. And now, Chief Counsel for the American Center for Law and Justice, Sekulow.
United States Supreme Court Justice Antonin Scalia has died.
Scalia was nominated to the U.S. Supreme Court in 1986.
I've had the honor of nominating Judge Scalia to be the Associate Justice of the United States Supreme Court.
Not many Supreme Court justices become famous. Antonin Scalia is one of the few. He is one of the most brilliant and combative justices ever to sit on the court.
For almost 30 years, Justice Antonin Nino Scalia was a larger-than-life president on the bench.
He was a tremendous champion of liberty and freedom.
A brilliant legal mind with an energetic style, an incisive wit, and colorful opinions.
American hero, constitutional giant, a conservative lion.
He influenced a generation of judges, lawyers, and students, and profoundly shaped the legal landscape.
Say Ronald Reagan brought the conservative movement back to the presidency. I think Antonin Scalia, without a doubt, brought the conservative movement back to the Supreme Court of the United States.
Justice Scalia dedicated his life to the cornerstone of our democracy, the rule of law.
Someone our country owes a debt of gratitude to, and that is Antonin Scalia.
I cannot think of what I would do for an encore. I can't think of any other job that I would find as interesting and as satisfying.
He was the leading jurist of our lifetime on the cases that mattered most. Well, as we mourn the loss of a great man, and that is Justice Antonin Scalia, we realize now that the president has put the country in a political showdown for control of the Supreme Court. Before Justice Scalia's body was even returned from Texas to Washington, D.C., the president, while thanking Justice Scalia's family for his service, immediately said he was going to nominate a new Supreme Court nominee in what he called due time, which generally for the president has meant anywhere from 30 to basically 30 days to 60 days, so over a 2-month period. Now, the president has the constitutional right. I want to be clear about this. The president has the constitutional right to nominate justices to the Supreme Court of the United States. What he does not have the right to do is just have it rubber stamped, because the second article of Article 2, Section 2, says that it's with the advice and consent of the United States Senate. So the reality is the president doesn't have the authority to do that on his own, and that is where the showdown, Than, is taking place literally today in Washington, D.C.
Yeah, that's right. The president has the constitutional right to nominate, but the Senate has the constitutional right not to consider it, Jay. And not only do they have the constitutional right, as Leader McConnell said, they also have 140 years or nearly 140 years of precedent that says in the final year of a term, the president does not get to nominate and have a Senate of the opposing party confirm that nominee. The Senate should exercise its constitutional right to wait until after the elections, to wait until after the American people have spoken.
All right, so let me tell you what we're doing. We're going to be talking about the cases that are being impacted by this, which are many. We're going to talk about the impact this has for the future of the country, which is huge. And we're taking your calls, and I want you to get involved in this. I said by the end of the day I needed 10,000, so we're 1,000 away from the 10,000 figure to start. So if you would go to aclj.org during this break, or call us at 1-877-989-2255. Add your name to the petition saying no SCOTUS nomination and confirmation before the election. We, the people, should have a say in this. It's the Supreme Court for the rest of our lives. aclj.org or 877-989-2255. Back with more in a moment.
With the death of Supreme Court Justice Antonin Scalia, our nation faces a historic moment. The next justice could impact the court and the direction of our nation for decades to come. Abortion, executive overreach, religious liberty, just a few of the critical issues before the court this term. The next Supreme Court justice should be thoroughly vetted and reviewed through the constitutionally prescribed advice and consent of the Senate, not rushed through the confirmation process before the end of President Obama's last year in office. The American people deserve a voice in selecting our next Supreme Court justice. That's why we're aggressively working in Congress to send a powerful message. There should be no confirmation of the next Supreme Court nominee until after the election. Sign on to our new petition right now. Call 1-877-989-2255. That's 1-877-989-2255 or add your name online, aclj.org.
Welcome back to the broadcast, everyone. You know, for a quarter of a century, I've had the privilege of arguing Supreme Court cases in front of Justice Scalia. 25 years. We've had 20 cases. I've argued 12 of those for 25 years, a quarter of a century. My legal career, you could track it based on my relationship with Justice Scalia as far as appearing before him. This is a tragic loss for his family, but a tragic loss also for our country. And it's going to have big ramifications. But let me reset. I did some of this yesterday, but I want to reset for you what the situation is. So Article 2, Section 2. Well, first of all, let's play where the president says he talks about Scalia, but then says he's going to nominate. So let's take a listen to this.
I plan to fulfill my constitutional responsibilities to nominate a successor in due time. There will be plenty of time for me to do so and for the Senate to fulfill its responsibility to give that person a fair hearing and a timely vote. These are responsibilities that I take seriously, as should everyone.
There is no obligation on the United States Senate part to give anybody a timely vote. Because let me read to the president and to you also, so you know this. Article 2, Section 2 of the United States Constitution provides the president shall have the power, by and with the advice and consent of Senate, to appoint judges of the Supreme Court. So the president has the power. There's no doubt the president has the power to make the appointment. He can nominate someone. That's fine. What he cannot do is demand that the Senate give them a vote, in fact, or a hearing, because it's all done with the advice and the consent of the United States Senate. And that's the reality here. And that's what we've got to insist on. We can't make any exceptions there. We have to insist on it.
Yeah, in fact, Jay, the Constitution ensures that if the Senate does not like a candidate or if the Senate does not want to consider one, they don't have to. The president can't move without them. You know, procedurally, Jay, we talked about this in the break, but our listeners need to know this. There are many, many places where the Senate can step up and block this nomination. They could do it by not scheduling any hearings, and that would be at the foot of Senate Judiciary Committee Chuck Grassley. You know what they could also do? Leader McConnell could just not send it to the committee in the first place, and the nomination would never proceed to the committee. Either one of those actions would stop the nomination in its tracks.
The duplicity here is really unbelievable. I mean, you got to understand this. Robert Bork was what we called borked by the Senate Judiciary Committee, who should have been confirmed as a justice to the Supreme Court of the United States and would have been a fantastic one. Miguel Estrada gets blocked by the Senate Democrats. We played for you in the open what Senator Schumer said about his view on what should happen with President Bush's nominees when there were 17 months, almost 18 months to go in his term, almost a year and a half. Listen to this. This is what Chuck Schumer said. First, I'm going to play for you what he said about blocking, and then I'm going to set it up what he said yesterday or 2 days ago. First, his block of President Bush's nominees.
The Supreme Court is dangerously out of balance. With respect to the Supreme Court, at least, I will recommend to my colleagues that we should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. I will do everything in my power to prevent one more ideological ally from joining Roberts and Alito.
So that was Chuck Schumer in 2007. Here's Chuck Schumer now.
Our job is to go forward with the process, and then we'll see what happens. That's what Democrats
it's not gonna happen.
Well, no, I'm not sure that's true. You know, the kind of obstructionism that Mitch McConnell's talking about, he's harking back to his old days. You know, he said, well, I want regular order. But in 2010, right after the election, or right during the election, he said, my number one job is to defeat Barack Obama, without even knowing what Barack Obama was going to propose.
Well, here you go. You talk about a double standard? There's your double standard. And Than, we've got to play that over and over again because I want to tell everybody what's at stake here. This is a battle for the Supreme Court for 2 generations. So my kids and grandkids, will be living with these decisions. This is the most significant battle that we are facing in our country right now on where the direction of the country will be, is who's going to be the swing at the Supreme Court of the United States. I think it is issue number one in the presidential campaign, and we cannot risk not knowing who the nominee is with a real track record. All right, we're going to take some phone calls. Stan, let me get your comments on it. I think this is the battle. I don't think there's any doubt about it.
No question about it, and it should be the battle, Jay. It should be a battle that's put before the American voters. And, just so people understand the sense of timing there, that sound you played from Chuck Schumer just now, that was a full year and a half before the end of President Bush's term. We are in the last year. And also, just to add to this layer of hypocrisy, Jay, Senator Schumer, when Justice Alito was nominated, he joined the filibuster. He joined Hillary Clinton, Joe Biden, John Kerry, and Barack Obama in filibustering Samuel Alito. So he can't have it both ways.
They're not getting it both ways, and we're not going to let that happen. And again, folks, we're just shy of 10,000, which is our first mark. We're going to want to march it up. But for Stan to start making the phone calls, of course, we're already in contact, but letting them know how many people we're hearing from. ACLJ.org, which is the easiest way for you to sign it. ACLJ.org, or you can call also at 1-877-989-2255. ACLJ.org or 877-989-2255. Susan Gorman said the people gave the Republicans the Senate. They better do what they promised. This was on, I guess this was on Facebook. Let me tell you something. They're saying it, but you got to hold them accountable. Let's go to Ike, who's calling from White Plains, Maryland. Hi, Ike.
God bless you, Jay, and all that you do and your crew.
Thank you, sir.
Yes, sir. The president has his past track record shows that he has made end runs around the Congress and Senate.
Yep.
What's to stop him from doing it this time?
The United States Constitution is what stops him. Because you cannot do an executive action appointment of a Supreme Court justice. You could do a recess appointment, but that would only be good for a year. But let me, again, it is with the advice and consent of the United States Senate. Article 2, Section 2 of the United States Constitution. That is what we're relying on. In fact, I'm going to have a memo done that we'll post in the next couple of days on what advice and consent means. And I'll have that for tomorrow for radio with the definitions of what advice and consent have meant. It's crystal clear. But this is what we have to do. We have no choice. We have no option. This is what we have to do. And we're going to do it. And you're going to help us do it, folks. So, again, aclj.org or 877-989-2255. The degree of advice and consent is not just roll over. We need to explain the process to everyone, Than, because there are multiple ways to stop this. And we could just stop it by not impaneling a committee or a hearing, period.
That's right. You don't even have to refer the nomination to the committee in the first place, Jay, or you could not have a hearing. And listen, I mean, if this vacancy had occurred at the beginning of President Obama's term, the nominee would get a hearing. But an intervening event has happened since then. The American people went to the polls and they sent a Republican Senate to the United States Senate to block these sorts of things. Right. That is to Suzanne's point that you just read, Jay, she is right. This is on Senate Republicans. This is not in President Obama's hand. He's going to nominate. It is up to Senate Republicans to stand in the way.
And we're going to fight back, folks. We're taking more of your calls. Let's go to Bill, who's calling in Green Ferry, Arkansas, line 2. Hi, Bill.
Yes, Jay. Hillary Clinton said that if she got the presidency, she would may go ahead and nominate Obama for the Supreme Court. Do you think that Obama may, knowing that she said that he'll wait on down the line, see where she's at in the election field, and hold off in nominating somebody and wait to see if she gets it?
No, he's going to nominate. I mean, he's going to try to fill the vacancy. There has been historic precedent. Taft, it was Taft, served as president of the United States, then went to the Supreme Court as Chief Justice, said that was his favorite job. Was the being a justice on the Supreme Court. He liked it better being president. But I don't know. The president's not going to wait to keep the vacancy open, so he might be appointed. That doesn't stop Hillary Clinton if there's another vacancy, and chances are, if whoever's the next president, there'll be a vacancy or two. So, I mean, we are talking about the control of the Supreme Court of the United States here, folks, for the rest of our lives. Now, I want to tell you something. I found solace standing before Antonin Scalia, a champion for the Constitution. A champion for liberty. You know, he was a figure larger than life. His opinions, I'm going to bring one in after this break. I'm going to bring one in, what he wrote on one of the opinions I have, and show it. a larger-than-life figure. We've lost a real hero of the Constitution and a real patriot. The president wants a showdown at the Supreme Court, and we're going to have to meet that showdown. And you're going to help us do it. We're going to stop this. President has the right to nominate. The Senate has the right to say no. So I want you to go to aclj.org or 1-877-989-2255 right now. Let's get this. I'd love to see this at 10,000 before the end of the day. aclj.org or 1-877-989-2255. Add your voice to this important battle for liberty, for freedom, to stop a Supreme Court nominee which will control the court for a generation. aclj.org or 1-877-989-2255. Let me also ask you to do this. Pray for the family of Justice Antonin Scalia. He was a man of deep faith. No question in my mind that man is in heaven today. But we have lost a champion, and 27 grandchildren have lost a grandfather. 9 kids have lost a father, and Maureen has lost a husband. Let's pray for that family. Back with more in a moment.
With the death of Supreme Court Justice Antonin Scalia, our nation faces a historic moment. The next justice could impact the court and the direction of our nation for decades to come. Abortion, executive overreach, religious liberty, just a few of the critical issues before the court this term. The next Supreme Court justice should be thoroughly vetted and reviewed through the constitutionally prescribed advice and consent of the Senate, not rushed through the confirmation process before the end of President Obama's last year in office. The American people deserve a voice in selecting our next Supreme Court justice. That's why we're aggressively working in Congress to send a powerful message. There should be no confirmation of the next Supreme Court nominee until after the election. Sign on to our new petition right now. Call 1-877-989-2255. That's 1-877-989-2255 or add your name online, aclj.org.
All right, we're back for a rapid-fire round. That means you get to ask the questions, and we answer them quickly. We've got a couple lines open for you, 1-800-684-3110, 1-800-684-3110. Ben, what's the atmospherics in Washington right now?
Well, this certainly injected a lot more drama, Jay. The Senate is not even here yet, but yet you're getting a lot of comments. When they get back, you can bet this is going to be the first thing up on their agenda.
Yeah, I'll tell you this. I think that this is going to be – we're going to get an announcement next week, I believe, from the president. So buckle your seatbelts, folks. This is going to be some ride. Let's go ahead back to the phones. We've got Travis calling from Montana on line 6. Hi, Travis.
Hi, Jay. Thanks for taking my call.
Sure.
Crazy question. It seems like we're going way off the direction saying don't consider any nomination. What if President Obama does something none of us expect? What if he nominates Jay Sekulow? What if he goes the direction we might want?
You know what? If he nominates Jay Sekulow, which he won't, but if he did, you know what I would say? Don't have a hearing. Don't have a committee meeting. Don't do it. First of all, could you imagine? I don't even want to go there. But I mean, I appreciate the compliment, Travis. But no, I think this is a no. No matter who it is, we say no. There's an election just days away, really, months away. So we need to do it. Kathy on Facebook said, who would be a good nominee? Oh, there's a whole host of judges on the Court of Appeals and others outside the court that I could recommend. I could give you a whole list, but we'll save that for another day. But there are plenty, but none that the president would select, however. Let's go to Eugene from New York City. Line 3.
Hi, Jay.
Hey, sir.
Hey, Jay, I just want to say thanks for everything you do. God bless you and your family. Jay, here's my question. Is there anything this president can do with executive order or executive branch action in order to extort, blackmail, or try to push the Senate to act?
Not blackmail, not extort, but, the president could do a recess appointment. It's only good for a year. It's not his first choice, but he could try it. But the Senate better not go in recess. That would be the safest thing.
Yeah, he could do a recess appointment this week, or he could also look at that intervening period after election. But again, I think the simple answer to this is no. And the political pressure will be extreme. The Senate has the constitutional right, Jay, to block this.
Yeah, this is the very first case I argued the Supreme Court of the United States, and that is Board of Air Commissioners versus Jews for Jesus 25 years ago. More than that, before Justice Scalia. He had a lot of questions in that case. Here's one of them.
Mr. Sekulow, would you explain to me, because I really don't understand this from your argument, what is it that makes a public forum special as opposed to any public building? Because as I understand your argument, I think what it boils down to saying is that any public building must be allowed to be used for free speech activities to the extent that such activities are not incompatible with the other uses of the building. Now, if you adopt that as a principle, why do you need a public forum doctrine? You don't need it. Doesn't it totally gobble up the concept that there are some public buildings where you don't even have to have reasonable time, place, and manner restrictions?
Your Honor, one important element of our analysis on this compatibility issue is that there's general access open to the public. And let's take an office building as a good example. You have an office building, narrow corridors. There is an argument can be made that the activities taking place inside an office building may not be compatible with the efficient operation of that particular facility. But it's that general public access coupled with the compatibility.
But even in a public forum, you are allowed to place such restrictions as are necessary to make the speech compatible with whatever else is going on there.
That's correct.
In a park, okay, and so forth. So then what difference is there between a public forum and a non-public forum in your view of the world?
A non-public forum, and arguments have been made regarding a non-public forum concerning the internal mail school systems. It's that public access was lacking, Your Honor, in that particular situation and many others. There are also cases like Greer v. Spock. There are special functions of facilities, military bases, where that special constitutional function is what this Court determined. That special constitutional function justifies the concern for national security, justifies in national defense the regulation or elimination in some cases of First Amendment activities from taking place. We're not saying that all facilities are public forums open to everyone. What we are saying is when you have that compatibility and general public access, that is what we're saying is part of the key, that compatibility and access. That's a balancing. The public forum issue is on a spectrum. Our position is that LAX on the spectrum of public forum is closer to a street, a sidewalk, or a park than it is to a military base or a prison.
So there you have it. That's, again, 9-0 in that case, by the way. Justice O'Connor wrote the opinion. But that was a good opinion. It was Justice Scalia. Jay is calling from Fairfax, Virginia, on line 5. Hi, Jay.
Hey, here's another nominee that Obama won't pick is Roy Moore, who I think's great. And
nobody that you would think will be nominated. That I could. Everybody that's listening to me, unless those of you that are Democrats that are listening, that are, or I should say, those that like the president's judicial philosophy, maybe more appropriately, maybe you have some. But for most of the conservatives listening, there is not a name, Jay, you're going to come up with, which is going to be on anybody's short, medium, or long list. But go ahead.
Right. Also, can the court effectively function and take arguments with what they have on the court? And I'd also like to say,
let me answer that question first. With 8 justices, yes, the court can still hear cases, but the Chief Justice can decide to hold some of those bigger cases over if he thinks it's necessary. So that's the reason. But go ahead with your next question.
Oh, it was more of a comment. I'd just like to say in Italian, Dio benedice to the Scalia family, which means God bless you.
That's very nice. Thank you very much. And we'll share that with them this week. Rob Stewart on Facebook writes, why don't we, the people, vote for Supreme Court justices? Because the Constitution gives them life tenure, which I actually think is the right thing. Gets them outside the political realm. We could talk about that another day this week, and we will. Let me try to grab another question here. Jackie is calling from Pennsylvania. Hi, Jackie.
Hi.
Yes, ma'am.
My question is in regards to when this happened back in the early 60s.
Yeah, the 1960s. Yep.
Yeah. And the Democratic Senate passed a resolution that there shouldn't be any appointments in the last year.
Of the so here's what happened. It was a sense of Congress. Resolution was passed, and that the president, because President Eisenhower had made a series of recess appointments that ultimately were confirmed. So the Senate Democrats, with only 3 Democrats voting no, passed a sense of the House Senate resolution saying that the president should not seek a recess appointment. So, Than, they've been beating this drum for effectively 60 years.
Repeatedly,
more than that.
Jay. Whenever the shoe was on the other foot, they have supported a last-year lull in these nominations. And you don't have to go all the way back to 1960. I like the point because they did pass that resolution. Just go back to 2007. Chuck Schumer, said in basically this exact situation, except with more time to consider it, he said that it should not proceed. So when the shoe is on the other foot, the Democrats also think that an election should intervene. But when they like the president, they think it should go forward.
All right, we're going to grab one last call here. Shuri's calling from California. Hi, Shuri.
Hi, Jay. Thank you so much for fighting for us.
Thanks.
I just have a quick question.
Yep.
I signed the petition.
Great.
I just want to know if you can explain to us viewers how that helps.
All right, so that's a great question. I'm going to answer and we'll let this man answer, but here's what it does. We become collectively, one person making a call is important. It's not the same thing as 150,000 people from all 50 states that we then let Congress or the Senate or the Judiciary Committee in this case know exactly where you are. So we become your voice, your echo chamber, if you will, inside the Senate, inside the courts when we file cases, inside the House. And then, so it makes a huge, huge difference.
Especially when the political pressure is going to be as big as it is this time, Jay. I mean, think about it this way. Along with that huge number you talked about, we can also take all of Kentucky's signers and send them to Leader McConnell and say, your voters don't want you to move forward on this. We can take all of the Iowa signers and send those to Chuck Grassley and say, we do not want a hearing held. We can take all of the New Hampshire signers and send them to Kelly Ayotte and say, your voters are behind you if you stand with us. When you're talking about something that is going to be as politically hot as this, Jay, wide numbers and representation from all of the states makes a huge difference.
All right, folks, that is going to wrap up today's broadcast, but I want to encourage you to do a couple things. Number one, I am going to be arguing a major case next week at the Georgia Supreme Court involving an obscenity statute that has ramifications for all 50 states. So it's a big case. We're representing the state of Georgia in that case. I was appointed a special assistant district attorney to do that argument for the state Supreme Court of Georgia. So I appreciate your prayers for that. Also, let me say this. This is going to be, we're not going to get a nomination this week, but I expect it's coming next week. And it's going to be buckle your seatbelts. And we're going to have to really work. And we're already on the start, but it's going to be a real work. So stay engaged with us. I want you to follow us on Twitter. Follow me on Twitter. Easy to do, at Jay Sekulow. Follow us on Facebook. Great way to get information. You do that at Jay Sekulow has a page. I have a page. American Center for Law and Justice has a page. Jordan has a page. Even the band has a page. So we encourage you to do that. And then, of course, sign that petition to let's not have a Supreme Court nominee. ACLJ.org or 877-989-2255. I'm going to be on with Sean Hannity this evening to discuss the Hillary Clinton email scandal as well as the Supreme Court appointment. So we'll want to stay tuned for that as well. We'll talk to you tomorrow.
With the death of Supreme Court Justice Antonin Scalia, our nation faces a historic moment. The next justice could impact the court and the direction of our nation for decades to come. Abortion, executive overreach, religious liberty, just a few of the critical issues before the court this term. The next Supreme Court justice should be thoroughly vetted and reviewed through the constitutionally prescribed advice and consent of the Senate, not rushed through the confirmation process before the end of President Obama's last year in office. The American people deserve a voice in selecting our next Supreme Court justice. That's why we're aggressively working in Congress to send a powerful message. There should be no confirmation of the next Supreme Court nominee until after the election. Sign on to our new petition right now. Call 1-877-989-2255. That's 1-877-989-2255 or add your name online, aclj.org.